the planning department proposed ordinance language that you can see in your packets by defining a non-commercial sign that shall be allowed in zoning districts except as otherwise provided. A, that they may be located anywhere on a lot, but not create a traffic safety hazard by blocking visibility of traffic, a public street from a driveway. Signs shall not overhang public sidewalks. However, when there is no sidewalk, no part of the sign shall be closer than 8 feet to the edge of the paved portion of the public way. That was the initial language. The initial language also included signs shall not be larger than 3 foot by 3 foot. The initial language also included that signs shall not include any names or logos advertising goods, services, businesses, or otherwise constituting commercial speech, and they shall not be artificially illuminated except as permitted in section 5.2.10. The committee held the public hearing. There were 3 folks who spoke to us, 2 of whom spoke passionately about the importance of free speech. The purpose of these amendments is to be comport with constitutional law, particularly with the protection of free speech as the issue, given recent court decisions. We agreed that we could move forward with this discrete amendment, but one of the folks who spoke to us specifically also said that they were feeling that the restriction in the size of the sign is also a limitation on free speech. The law department advised us that it is not, in their opinion, because it does not regulate content, only size. The committee discussed this. Councilor Krinsman moved to strike that language from the proposed ordinance, which the committee upheld. And then it was decided to add a sentence, signs shall not create a public safety risk, to the first section, which it has some very specific language about traffic safety and so forth. That's really the report on the item. I believe it was Councilor Baker who put it on second call.
Let me provide context here. What I'm going to do in a few minutes is move an amendment to restore the 3 foot size limit, 3 by 3 size limit, as originally recommended by the planning department, supported as legal by the law department, as Chair Crosley has indicated, and also supported by the planning board in its vote that members of the council have before them. Just to provide the background, however, I don't know if it's possible for the clerk to show it, but the existing language of election signs, which is being dealt with, as well as yard or garage sale signs, those are all proposed to be changed to delete those references in the ordinance with some brief retentions I'll explain in a minute. But I think, who've run for office know that in the past we've assumed that a sign, because of the way the city's ordinance reads, has to be taken down within a certain period of time. There is also an aggregate limit on the number of square feet of signs you can have on your property. And there was a 3 foot limit. There's also an existing limit in the ordinance against obscenity in a sign, even a political sign. So what the law department, the planning department, and the planning board voted was to remove some of those limitations. So the limitation on aggregate size would be gone. The limitation on obscenity would be gone because obviously some speech can be seen as obscene, but it's also protected by the First Amendment. But they did retain the 3 by 3 provision as a reasonable limitation to protect the visual quality of the city. I would like to move to restore that 3 by 3 provision because it is in our existing ordinance. And I think the law department was very clear about its constitutionality. If there's any doubt about that, Mr. Lee, I called him after the meeting to double check. He sent me an email, but I haven't shared that with the council. But if there's any doubt, we can put the item off until every member of the council is fully satisfied about that. But I think it's pretty clear that it's not a legal matter, it's a policy judgment. And I think that Newton has been remarkably free of billboards or any size, oversized signs for years, with a few exceptions near the turnpike. But this change would, for non-commercial signs, allow a sign of any size. Now, it is subject to a limitation on public safety, as indicated, but that's, in my judgment, insufficient and also is difficult, I think, to interpret in some contexts. And this is a protection that we ought to have for citizens. So I would like to move that we restore what is an existing restriction in our current sign ordinance, the 3x3 limitation on an individual sign. You can have multiple signs of that size. It's not that there's a limit on the number now, because that would go away. But there is a limitation, because I think it's important that we have some controls now that there's no longer a durational limit, no longer an aggregate number of square feet limit, and obviously any content limit at all. And we can imagine a variety of things that could go on very large signs that might not be desirable to see in the city in terms of the scale. So I would like to move that amendment. I hope there's a second, and I hope the council will support it, and then we can vote the ordinance retaining that specific provision.
Seconded by Councilor Leary.
We're dictating the terms of what political signage people can or can't put on their lawns. And frankly, it is not our business. It's not our business to be telling people, unless it's a public safety issue, it is not our business to be telling people when they can put up the political signs, what the content of it is, when they have to take them down, or indeed what the size is. It's just as absurd to have the restriction that we've had in place for years, saying that you can only have one sign for one campaign on one lot and that you can't put up two signs for the same candidate. These are absurd aesthetic restrictions that are purely a subjective matter. And I think that I don't agree with the law department's interpretation of this particular restriction being constitutionally inbounds. And it's just not our business to tell people, and we're going to get ourselves into more trouble if we keep trying to add these restrictions in.
I don't think 3x3 is in any way infringing on our First Amendment rights. The law department agrees with that. I also want to remind my colleagues that the planning department is undergoing a full review of all our sign rules and regulations in a comprehensive way, which I think is a much more sensible approach at this point. So what I'm concerned about is huge billboards, just as has been mentioned, that you see commonly in Boston or other cities or towns that do not have restrictions. I really am not crazy about seeing an 8-foot by 4-foot political sign in Newton. We don't allow, now we're not allowing restrictions on the number. We're not allowing any timeline. You can have them up all year round. I think we should support this amendment, Councilor Baker's amendment, which I think makes sense, and then we can review it further when the planning department takes this up comprehensively. So I urge my colleagues to support Councilor Baker's amendment. Thank you.
Thank you, Madam President. I rise in opposition to the amendment, and I'll briefly explain why. First of all, I want to say that the underlying ordinance change we have before us is terrific. It is designed to remedy an unconstitutional situation that we had here in Newton, and I am very supportive of the ordinance changes. I think probably we are all supportive, and we are just sort of, on the edges here about one particular matter. I moved in committee that we eliminate the restriction on size in terms of 3x3 for a couple of reasons. First and foremost, it is political speech. I don't think anyone would doubt that political signs are political speech, that they are protected under the First Amendment. This applies to actually all non-commercial speech, so it's not just the signs for us, for our opponents, but other messages, Black Lives Matter, support the fire department, save our schools, all those messages. Excuse me, and this is how most people speak politically. We come here every couple of weeks, we come to our committee meetings, but for our residents, it's a very personal thing, and their ability to speak, their ability to have their First Amendment rights protected comes down to the signs that they put in their yards. And so to constrain those signs to a particular side is no doubt a constraint on that speech. The question is whether it's a reasonable constraint and whether it's something that we can do. I think the law department has found that it is constitutional. They may very well be right, but that doesn't mean that it's something we have to do. They may be wrong. It may be unconstitutional. We don't know the specific answer to that question. But the question is, to what end? Why would we limit the signs to 3 by 3? To me, allowing them to speak is a little bit more important than whatever reason we would have to limit the size of those signs, the aesthetics